Okay, sharing? Are we sharing? Yes.
Yep.
Okay. So we've got a few updates from the last episode. We want to show everything that I've filed since then, which I believe is right here. Okay. Notice of violations of the Americans with Disabilities Act to the Honorable Judge of the above titled court comes now. Kennedy Walker, the defendant in the above captioned case, appearing pro se and respectfully submits this notice of violation of the Americans with Disabilities Act, ADA, by the Malheur County Circuit Court. In support of this notice, the defendant states as follows. Background on 7/17/24 and 8/8/24, the defendant submitted documents via email to the Malheur County Circuit Court for filing in connection with the above referenced case. The court, however, refused to accept these documents by email, insisting that they be filed either in person, by mail, or through the court's online portal. ADA violation. The defendant has physical disability that severely limits mobility, making it difficult to visit the post office or court in person. Furthermore, the defendant has chosen not to utilize the court's online portal due to personal preference and potential accessibility concerns. I had two problems with them, is why I mentioned that. By refusing to accept documents via email, the court has failed to provide a reasonable accommodation as required under the Americans with Disabilities Act, 42 U.S.C. 12101 at SAC. Which I don't know what that means. Do you?
I think it means and so forth.
Okay.
I think so, anyway. I'm not sure about that, but that's what I think it means.
Request for accommodation. The defendant requests that the court accept filings via email as a reasonable accommodation under the ADA. The ADA mandates that public entities, including courts, make necessary modifications to policies, practices, or procedures to avoid discrimination based on disability. Refusing to accept email filings creates an unnecessary burden on the defendant and violates the spirit and letter of the ADA, Americans with Disabilities Act. Legal basis under ADA, public entities must provide reasonable accommodations to individuals with disabilities, which, guys, I'm severely disabled. Severely. The refusal to accept email filings constitutes a failure to provide such an accommodation and discriminates against the defendant based on their disability. Wouldn't you agree? I would. I don't know how else you can
Oh, yeah,
see
definitely,
it.
man. I mean, and the ADA is something that they don't really want to screw around with because those people are serious, man, that are in charge
it's a law. The courts are bound to the law under Article 6, Supremacy Clause. 10th Amendment limits what states' laws can be. Okay, so this is ADA. That's federal. All right? So if they have a state law that says, no, you have to do it like this, but then there's the ADA saying something else, then it's null and void. Exactly. Wherefore, the defendant, myself, respectfully requests that this honorable court grant the relief requested and take all necessary steps to comply with the Americans with Disabilities Act. 16th of August, which was a week ago, right?
Yeah.
And
so you've already submitted that one?
Right, by email, okay? And that's what they're crying about, is that I'm using email instead of their portal or physically sending it in the mail. Okay? That's what they're crying about.
Yeah, of course, because then they would have to actually do a little bit of work besides just ripping open a letter.
Exactly. Well, here's the problem. First off, I have a printer, but it's broken. So the print function doesn't work. So I don't have a printer. Okay. I don't have a printer. That means that even if I wanted to fill this out and send it in by mail, I can't. As far as the online portal, it was nonsense. And I called a woman today at the court and told her the problems that I was having with accessibility to the court's online portal right here, right at the end.
Yeah.
And
yeah.
would she hear it? No. She's just here to collect a paycheck, same as the rest of them. The defendant...
they don't want to actually fucking work, these people, man. They're just... They're like the laziest, lowest form of life on planet Earth. These
they want to
bureaucrats,
insist
man.
that they don't work for us. That's honestly, that's their number one function, is to just insist that, like, guys, the reality is that this person is here to facilitate me, the system.
That's right.
That's the truth. And what are they in denial of? Reality. So is that going to work? Not for them. So I'm saying they've refused to provide a reasonable accommodation.
Right, which they're supposed to do. I mean...
Bro, I haven't been able to walk for 3 weeks, and if you think that it wasn't because of these people's, they took custody of me, but did they take any responsibility? No, they never do.
No, of course not.
So, my request for accommodation, the defendant requests that the court accept filings via email as a reasonable accommodation under the ADA. The ADA mandates that public entities, including courts, make necessary modifications to policies, practices, or procedures. Okay? So, they're saying, our procedure is this, right? The ADA, guys, this is what ChatGPT says. I'm not even making this shit up. This is what ChatGPT says, that they need to make necessary modifications to policies, practices, or procedures to avoid discrimination based on disability. And that's me. I'm disabled. I'm disabled. I've been stuck in my chair for like weeks. I haven't been able to leave my house. I don't have a printer. Okay? They say sign up with the online thing, and what does it want? Financial information, which I'm not willing to provide. So,
yeah, you shouldn't have to.
I don't feel I should have to. They're attacking me. When is it that they're going to show some sort of reasonable proof that they have a right to attack me?
Right. Yeah, well, they don't, they don't feel that they have to, but, eventually somebody's going to have to take responsibility for their fuck up. And it's not that they made a mistake. They're coming after you maliciously, man. This is official repression.
These people have signed sworn statements that are lies.
Right. And
so now one of us goes to prison. One of us. It has to be. Go ahead.
Yeah, like the charges, we went over this, when we had our conversation the other day, that the statutes don't even line up with what they're charging you with.
We'll get to that.
That shit's crazy, man. That shit's crazy.
That's the next one. Wherefore, the defendant... Oh, what?
No, go ahead.
No, you tell me.
No, go.
Okay, wherefore the defendant, Kennedy Walker, respectfully requests that this honorable court grant the relief requested above and take all necessary steps to comply with the Americans with Disabilities Act. So this is a notice. Understand, guys, this is it's not a motion, okay? This is a notice of violation of the law. This is the second one I've filed here. The first one was about my recording rights. Okay. All right, let's move on from that. Yep. Motion for jury trial. Kennedy Walker states as follows: constitutional rights under the Sixth Amendment to the United States Constitution and Article 1, Section 11 of the Oregon Constitution, the defendant is guaranteed the right to a trial by jury in criminal cases. So this is a motion for jury trial. Legal basis is the law. Interest of justice, we need a jury because the state's already failed to understand the law as it's written. Timelines, trying to get it to them in time, but they refuse email. Right? So, can I even accomplish that? I'm trying to get it in time, but they just don't like it. And so they're not going to accept it because they don't.
They have to, or it's a 14th. Yeah, it's a 14th Amendment violation if they don't take their email. Email has been an accepted form of submitting, all kinds of official documents for almost 30 years, man. Jesus Christ. These people, they'll do anything they can. They probably they sat down and they said, he doesn't get around very good, so let's not take any of his shit by email. We'll make him send it to us. Right. They've collaborated to make this happen.
Right. So this one here is a request for motions hearing and jury trial because that motion is included. Okay, so let me explain this as succinctly as I can. I wrote a motions hearing, which I've already published.
Oh, sorry, man. I muted you on accident. I'm sorry.
Okay, what do you want me to go back to?
When you first started talking about the motion.
Okay, so I filed 2 motions hearings. One of them was a narrowly purposed motion hearing to determine the motion to compel the prosecution to produce discovery. And then I haven't heard anything from them. We're getting closer and closer to the court date. So I went ahead and filed this, which is a full motions hearing. Full. Okay, so the defendant in the above captioned case, appearing pro se, and respectfully requests this honorable court to schedule a hearing on the defendant's motion to suppress and motion to dismiss with prejudice, which I filed both of those. We'll get to them in a minute. Both filed on August 21st, 24. Additionally, the defendant requests that the court grant a jury trial in the above matter. In support of these motions, the defendant states as follows. Nature of case. Defendant is charged with offenses related to the drug war, ORS 475.752, attempted unlawful delivery of a Schedule 1 controlled substance, Class B felon, and ORS, same thing, but 3A, unlawful possession of a Schedule 1 controlled substance, Class A misdemeanor. Purpose of hearing, the defendant has filed a motion to suppress and a motion to dismiss with prejudice, challenging the admissibility of evidence and the validity of the charges on constitutional grounds, included but not limited to violations of the 1st, 4th, 6th, 10th, and 14th Amendment, the Supremacy Clause of the U.S. Constitution, and the obstruction of commerce, which infringes upon the defendant's life, liberty, and the pursuit of happiness. Strict adherence to the 4th Amendment. The defendant asserts that the 4th Amendment to the United States Constitution is clear in its protection against unreasonable searches and seizures, which are only considered reasonable if conducted with a warrant signed by a judge. The plain language of the 4th Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Oath or affirmation by the complainant. The requirement of oath or affirmation underscores that any warrant must be supported by a sworn statement from a credible source, typically the complainant who has been harmed or directly involved. Corpus delicti, the injured complainant. Corpus delicti. Now, how do you say this in English? Well, injured complainant.
Yep.
Corpus
Yep. The injured
delicti
person.
is pointing to that concept, injured complainant. This ensures that the issuance of a warrant based on genuine and verifiable probable cause, not merely on the subjective beliefs and opinions of others. The warrant must be granted in the oath or affirmation of a complainant who can attest to the injury or harm suffered. That's important in the legal system. Guys, we have a checks and balances system. That means that some psychopath just doesn't decide if you end up getting your car towed and you go into jail. Checks and balances. So,
Yeah, exactly.
warrant issues and lack of evidence. The defendant was arrested without a warrant present at the time, which I'm not going to fight with these idiots. They're tougher than me, and there's always more of them than me, obviously. Yeah.
Right. Yep.
When a warrant was eventually produced, it appeared fraudulent, lacking the necessary legal elements, including an injured complainant. This failure to present a valid warrant at the time of arrest and a subsequent production of a questionable document constitutes a violation of the Fourth Amendment as established in Grove v. Ramirez. Now, the problem is that we have a warrant requirement in the Fourth Amendment. And now,
Yeah, and they haven't met it at
now
all.
here I am citing a case precedent. But
Yep.
what's the benefit here is that we're talking about a case precedent that upholds the Constitution. So
Right.
it's valid. It's valid.
Yeah,
Now,
it's
Terry
just
v. Ohio?
it's a fruit of the poisonous tree.
Well,
Yeah.
Terry v. Ohio
it violates-
object based on that it violates the Fourth Amendment, right? But
Right, exactly.
Grove v. Ramirez upholds it. 540 U.S. 551 2004. Those are all citations that ChatGPT added for me. Very nice. If I was good, I would check all of them. But the prosecution lacks any evidence, particularly evidence that was lawfully obtained through a proper warrant based on corpus delicti. This raises concerns about potential perjury and a presumption of guilt without admissible evidence. Witnesses versus injured complainant. Guys, they sent me a list of witnesses recently.
Yeah.
They
Yeah. So,
They think they're gaining something by doing that.
well, that's what they do, man. They're
They-
basically a bunch of retarded crooks, man. That's all they are.
Yeah, they think they're tricking me into now there's an injured complainant, but no. No, we
It's too
just
late.
got
It's too
this
late for that.
person.
Yeah, it's too late for an injured complainant now. There isn't one. There never
isn't
was.
one, and this law doesn't even actually allow for one. How does it?
Nope.
How can you be injured by what I have in my pocket or whatever? It doesn't
Right,
even
that
allow
you never saw.
for a complainant because no one could possibly be injured by what I have in my pocket. Like what? So the defendant asserts that the presence of witnesses to an unconstitutional law. Remember, this is a state law. It's subservient to federal law. I have a federal right to freedom of religion. I have a federal law to be secure in my property. I have federal laws that protect me from not having an injured complainant, such as the Sixth Amendment, right? So the defendant asserts that the presence of witnesses to an unconstitutional law does not substitute for the requirement of an injured complainant. Under constitutional principles, for a crime to be prosecuted, there must be a complainant who can demonstrate injury or harm. Corpus delicti. The U.S. Supreme Court has consistently held that laws must be interpreted in a manner consistent with constitutional principles, including the requirement that a valid complaint or charge must involve an injured party. In Marbury v. Madison, oh, that's interesting. They changed the words of that for me. Oh, well. The court established that any law repugnant to the Constitution is void. Therefore, without an injured complainant, the charges lack a lawful basis. That's true. An injured complainant. I've said it a million times, haven't I?
Yep, injured complainant. Injured complainant, sworn statement of it, injury and damage.
Yeah, it's corpus delicti. Corpus delicti. So, with the maximum sentence of 10 years in prison, the absence of an injured individual accusing the defendant is beyond excessive and without merit. Guys, think about how ridiculous that is, where no one stands up there and says, this guy hurt me at all, but 10 years in prison? That's preposterous.
It's crazy.
So, witnesses provided by the state are remember, they're not complainants that have been injured. They're complainers that want to invoke their rights against their religious beliefs against me.
Right.
Provided by the state are participating in the enforcement of a law that is unconstitutional and therefore null and void. These witnesses are effectively acting as agents of the state in the ongoing drug war, which the defendant argues constitutes treason under federal law. That's Article 3, Section 3, and 18 U.S.C. 2381. Both are treason. Yeah, treason's in the Constitution. It's also in U.S. Code. It falls under both.
Sure. Yeah, absolutely. And, well, yeah. I mean, it probably falls under several other articles.
Deprivation of rights under color of law, conspiracy against rights. We've got extortion in the mix. They tried to kill me. That's an RICO. Attempted murder under RICO for all of them, really. You're like, oh, the judge had nothing to do with that. Well, yeah, but the thing is that when the judge heard me tell him that there is no injured complainant, and he
should have dismissed right there.
He should have dismissed the case immediately. He really should have. When I invoked my right to face my accuser and all they could come up with is witnesses, the judge, he's taking part in it now because he should have been an impartial arbiter and he should have been like, oh yeah, that's a good point. There is no injured complainant. You want to put him in prison for 10 years? Let's put you guys in prison for a while.
Yeah, let's put the real crooks in prison because, look, if they could get convictions on possession, then they, without actually seizing some kind of a substance that was in your pocket or in your car or in your book bag or whatever, if they don't have it, they have no evidence. Now, if they could just say, well, we thought he had because he said he had, blah, 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 then we're going down a rabbit hole where everyone who, draws the baleful gaze of Mordor, any of these socialists, is liable to face these kind of charges with no evidence but witnesses, state witnesses of nothing. They just make up a story. And how many times has that happened? We don't know.
Millions.
How about every single time?
Millions.
Like, if they could do that shit to Pablo Escobar, why didn't they? Or any real drug dealer. Why do they make these huge efforts at these undercover sting operations to get these people when they can just say, well, we we think he had drugs, so we'll throw him in prison for 10 years without any kind of evidence. That's the precedent that they're setting with this case, because they got nothing. They don't have any. They got no evidence. All they got is hearsay from a bunch of fucking collaborators, man. That's all they got.
Right.
All they got.
Furthermore, the enforcement of these laws amounts to an attempt to impose a specific set of religious beliefs through state power, which the defendant contends is a form of terrorism.
Of course it is.
The First Amendment of the U.S. Constitution prohibits Congress from enacting laws that establish a religion or prohibit the free exercise thereof. The involvement of state agents in enforcing laws that violate the defendant's religious freedoms is a direct constitutional contradiction to this constitutional protection. The defendant further argues that the use of state power to enforce these unconstitutional laws constitutes an act of terrorism, as defined by federal law 18 U.S.C. 2331, which includes the use of force or violence to coerce a civilian population or influence the policy of a government through intimidation or coercion. Like, what's the drug war, guys?
It's treason, it's coercion, it's intimidation, it's murder, it's kidnapping.
Their beliefs.
It's a religion.
Their beliefs,
it's a religion.
where they just think everyone should follow their belief system. The state's actions in this case, therefore, not only lack legal standing, but also violate fundamental constitutional rights and laws, really. Law. Violate the law. Crime. It's crime.
Yeah, of course it is.
They're
violating the highest law of the land, man. I mean, that's just all there is to it.
Yeah. The defendant asserts that the police officers involved felt they had a right to redress their grievances with the defendant, which they do not have. The officers were lawfully trespassed by the defendant and arrested for creating a disturbance. The officers have violated the defendant's rights under citizens arrest law to disrupt the defendant's business. These actions by the officers further emphasize the constitutional violations and lack of legal basis for the charges. Think about this, guys. I arrested the officers involved, and now they're trying to stand there and swear against me. A jury needs to find them guilty or not guilty, guys. Violations of the Eighth Amendment and ADA compliance. The arresting officers used excessive force against the defendant by pushing them onto the ground and jerking them up by their arms while handcuffed behind their back. It's a weird subjugation. The way they're writing the pronouns, but I don't know. Maybe it's acceptable. I have no idea. The defendant was subjected to cruel and unusual punishment in violation of the Eighth Amendment when they experienced near unconsciousness and uncontrollable convulsions while in the intake area of the jail. They were left in an estimated 50-degree temperatures on cold cement, exacerbating their disability and preventing them from being able to get up. This treatment not only constitutes cruel and unusual punishment, but also reflects a pattern of discriminations and violations of the Americans with Disabilities Act throughout the handling of this case. The defendant is still feeling the effects and fears. They may be permanent. The court have also neglected important email documents and then refused them, which the courts have also neglected important email which seems to indicate that my inability to leave the house or even walk for much of the last month will impede my fair hearings. The state's maniacal treatment is likely the reason for the defendant's exacerbated physical deterioration. So a person with shame might try to do better from now on, but not when they can get away with it, it seems. Pressing the state's religion as terrorism pressing the state's religion at the barrel of a gun constitutes terrorism. The actions of the police and the state in enforcing laws that conflict with the defendant's religious practices, using threats and force, amount to religious persecution and terrorism. This further underlines the violation of the defendant's First Amendment rights and the unconstitutional nature of the charges. Unclear laws and narcotics schedule discrepancy. The recent changes in the legality of various drugs, including the legalization of some substances, raise significant questions about the clarity and fairness of the laws under which the defendant is being prosecuted. The ambiguity surrounding the classification and legality of certain substances may create a Ninth Amendment precedent, as the voters of this state have expressed their will through recent legislation. The Ninth Amendment protects rights not explicitly enumerated in the Constitution, suggesting that the evolving legal landscape should be considered in the defendant's case. The documents presented by the prosecution claim that the defendant possessed a Schedule I controlled substance. However, without a lab report establishing the identity of the substance and its alignment with the narcotic schedule, the charge is based on assumptions rather than concrete evidence. This lack of clarity in evidence undermines the prosecution's case and further supports the defendant's arguments for dismissal. Request the court schedule a hearing on the motion to suppress and motion to dismiss with prejudice. They're up in the mix. It's basically similar. You know, everything is collaborated into this document. I don't know if that's right. That's just what I did. But, you know, I mean, come on. Let's look at all these violations. Wherefore, the defendant respectfully requests that this honorable court schedule a hearing on the motion to suppress and dismiss with prejudice, grant this motion for a jury trial, schedule the trial to be heard before a jury at the earliest convenience of the court. The defendant is available on any day, exception of medical conditions that are not predictable. The defendant suffers from serious medical problems and has regular occurrence of not being able to leave the house. This is why the defendant has requested the option of hearings by phone or internet. All right, so that's the motions hearing. This is the motion to dismiss, which it's basically informed by that other document. And you could theoretically, get rid of this.
So yeah,
do that if you want.
Yeah, you basically are educating them on what they should be doing, which to me is insane that we should even have to do that. That you should even have to do this.
It's all. Yeah, nobody along the line actually. Let me get to the bottom of this, I guess. In case you want to read it, you can pause it and all that. Okay. All right. I'm going to stop sharing, and then I'm going to go back to here. Okay.
Yeah. So
should I have to invoke my rights? That's an interesting point.
No,
there's a lot of complexity within it. Because essentially, once you get through my motions, don't you kind of know that I can't be charged?
Yeah, absolutely, man. You know,
and if
this is all retaliation.
Less than that, then don't you kind of wonder if maybe you could be charged? Because you got to do it all. The whole... Bro, there's 8 reasons why I can't be charged, I think, is what it came down to. 8 reasons.
That sounds about right.
And so when you go into court, if you don't have 3 reasons or 5 reasons or 8 reasons, then shouldn't you kind of expect like the worst?
You
need only one, technically.
Right. And that would be the lack of physical evidence.
Well,
as far as I'm concerned.
If
There
they-
shouldn't have never been a warrant in the first place, man, because they had no evidence. They didn't have any controlled substance. They never had it. Even if they saw it, they never got it. So they can't prove what it was.
it's an illegal
And it's
search
not like you were
anyway.
holding up a bag of mushrooms going, hey, I want to sell this. You weren't. It's crazy, man. It's just insane.
Well, and there's no corpus delicti. Injured complainant.
Right. No injured complainant.
These people need
What
to
we
get
had
over
was a
that
bunch of
because
Yeah, what we had was a bunch of hurt ass cops. You know, they got butt hurt
they thought they were
because
the
you dressed them
commander.
up. Yeah, you dressed them up and you told them exactly what was what. Exactly what was what. And this is all just retaliation. It's retaliation.
Yeah, for sure.
Is
well,
what it
I
is.
mean, come on. It's pretty obvious. I've arrested
Yeah,
so
yeah.
many of them. Have any of them
Yep.
seen a jury? No.
No, fuck no, because they're all part of the club, man.
So
All
what
part
is
of the
that?
club.
I mean, every single time, that's more crimes on everybody around for
Yeah,
collaborating.
it's
It's that
it's,
they took an oath to our laws, and they're not going to uphold that. They never will.
yeah.
Ever.
It's an exponential increase in the amount of crimes committed against you every single time.
They got to,
Like producing these witnesses.
they
That's a
gotta say
crime.
it's
That's
me.
crime.
because otherwise it's them, right?
Right.
It has
Yeah,
to be
yeah.
me because otherwise it's them. Yeah, so they're trying to charge me right now with another crime.
Yeah, so we got about 10 minutes, man. Let's hear it. I'm interested to hear about this. I don't know anything about this. So let's go.
Let's see. Okay, so let's see. This is the document that I have. Okay, so here's what they're accusing me of. That I interfered with a peace officer, Class A misdemeanor, and that one. And I have an arraignment on the 27th.
Interference is a physical act. Interference is a physical act.
Hopefully that's August. I don't remember.
Wait a minute. Wait. Oh, okay. It's on. When did this thing happen?
Well,
It
we
happened
tried
when
to
you-
look it up. I don't know.
Yeah.
I think it was the 17th of July. So I think that needs to be changed to August because this is the court hearing.
Right, but when did the violation occur? That's what I want to know. When did they say that happened?
The day when this cop pulled someone over in front of my house. So he engaged his emergency lights. So that's misuse of emergency lights. And then he created a disturbance in my neighborhood. Also, he seized a man without a warrant. These are all violations. And they're trying to say that it's me that violates by doing that. This is the law, which doesn't line up with it because act. What did I act in a manner of? I didn't act at all. I spoke. So my
Right.
my freedom of
Interference
speech-
is a
interference
is a physical act, man.
Yeah,
I mean,
everybody
that's
knows
it-
that.
Yeah.
So did I act in a manner that prevented someone from doing anything? No, of course not.
No.
And besides
they-
that, okay, peace officer from performing lawful duties. What's a lawful duty? Well, they have police power once they have a warrant.
Right. So there's no lawful activity
Right.
unless there's
So
a
I
warrant,
was
which there
objecting
wasn't.
to unlawful activity, which
That's
is
right.
why I filed a criminal complaint on them. Is this gonna let me through?
Yeah, these people are they're doubling and tripling, and they're gonna nitpick every little single thing. And
Okay.
yeah,
this is what I got already for them. Just gonna go ahead with the motion to dismiss real quick. Defendant me, representing oneself, and hereby moves this honorable court to dismiss the charge of interfering with a peace officer under this. Dismissal is warranted on the grounds that the defendant's actions were protected by the First Amendment of the United States Constitution, that the peace officer lacked lawful authority, and that the defendant was engaged in a lawful private person's arrest. Yeah, I arrested that man for creating a disturbance in my neighborhood. Of the officer for disorderly conduct and other violations. He deprived a man of his constitutional rights, and there's tons of them. You can just keep going. Protected speech under the First Amendment. The charge against the defendant is based on verbal statements made by the peace officer, which include asking for a warrant and advising another individual of their constitutional rights. These statements are protected by the First Amendment, which guarantees the right to free speech and to petition the government for a redress of grievances. The defendant's speech did not constitute interference as defined under the law. Now, this is what ChatGPT says. I told them what happened, and that's what they came up with. But was instead a lawful exercise of constitutional rights. People are always like, oh, you're so stupid. Guy, it's ChatGPT that I just tell them what happened exactly. And this is the type of stuff that they spit out for me.
Right, and ChatGPT looks at the facts.
Yeah, well, I just tell them the facts. I tell them exactly what I said. Okay, and then, that's fine. Supporting authority, Houston v. Hill. Supreme Court held that the First Amendment protects verbal criticism of law enforcement officers. State v. Osmus. Oregon Supreme Court held that mere speech does not constitute interference unless it obstructs the officer's performance. Yeah, how can I obstruct it by mere speech? Right. Lawful exercise of a private person's arrest. The defendant placed the officer under a private person's arrest for disorderly conduct under ORS 133.225, asserting that the officer was creating a disturbance in the neighborhood and creating alarm by seizing an individual without a valid warrant. The defendant was the complainant reporting a crime, and this charge of interfering with a peace officer appears to be retaliation for invoking the citizen's arrest law. Under ORS 133.225, 1, a private person may arrest another for any crime committed in the person's presence. The defendant observed the officer committing what they believe to be a crime, disorderly conduct under ORS 166.025, 1A and B, by engaging in behavior that was alarming and created a public disturbance. ORS 133.225 grants private citizens the authority to arrest another person if a crime committed is committed in their presence. 166.025 defines disorderly conduct, which includes behavior that creates alarm or causes a public disturbance, lack of lawful authority, and invalid warrant. ORS 162.2471 requires that a peace officer must be performing lawful duties to sustain a charge of interfering with a peace officer. In this instance, the officer did not present a warrant, and any warrant produced at this stage would be meaningless due to concerns regarding the validity and authenticity of warrants issued in this county, as they often lack the necessary corpus delicti. The officer's actions therefore lacked lawful authority, and the defendant's insistence on a warrant was not interference, but a lawful demand for constitutional adherence. State v. Olson 282, Oregon's blah blah blah. The Oregon Supreme Court establishing the legality of an officer's duty is a necessary element in charges. So, Map B. Ohio reinforces the requirement that a search and seizure must comply with the Fourth Amendment. Retaliation of lawful actions. The charge of interfering with a peace officer is likely retaliatory, as it followed the defendant's lawful arrest of the officer for disorderly conduct. The defendant's actions were not only lawful but constitutionally protected, and this charge appears to be an attempt to punish the defendant for asserting those rights. Supporting authority, Hartman v. Moore. The Supreme Court recognized that retaliatory prosecution can violate the First Amendment if it is motivated motivated by an individual's exercise of free speech. Conclusion, the defendant respectfully requests this court dismiss the charge of interfering with a peace officer. The defendant's actions were protected by the First Amendment, justified under the law governing private person's arrest, and did not constitute interference with any lawful duties. Moreover, any subsequent production of a warrant is insufficient to legitimize the officer's actions, given the concerns about counterfeit warrants in this jurisdiction. So,
yep, that's man. Yeah, it's a whole nest of vipers, man. But they don't have a leg to stand on. All right, listen, man. Thanks for giving us this, Kennedy. I have got to go, man. I'm on a really strict. I'm on a very tight schedule today. I appreciate you guys that showed up. We got some interesting developments going on with this case. I'm gonna.
All they're doing is lining up to get fucking wrecked.
Yeah, they are.
What the hell they think? But it seems that they can't even read these state laws. They can't. I mean, what the hell is going on here? When no one can read,
know what it is.
No one knows the law. Our prosecutors and district attorneys, they don't know what the law is. They have no clue. The judges, they have no clue that we have constitutional rights, and they think that their state laws override them. Bro, this is preposterous.
It is preposterous. It's just as preposterous as assuming that Panera Bread can make a product without a recipe, right? I mean, that's what it is. These people don't even know what the recipe is.
And this recipe that they're operating on is totally faulty. They don't have corpus delicti. This is like fucking 500 goddamn years old.
Yeah, it's probably even older than that. Probably goes all the way back to Greece, I would imagine.
Probably, yeah.
You know, as far as a concept goes, probably goes all the way back to Plato. Yeah, probably goes all the way back to Plato, man, and Socrates. All right, brothers. Thank you for coming, Kennedy, and thanks, guys, for showing up. I'm going to end the stream. Hang out for a minute, Kennedy. All right, later, guys. Okay. Remember, like, subscribe, and comment in whatever order. I really don't care. Later, guys.